do. We had such a success on the call last week with Judge Landers and all the questions he was gracious enough to take with us. The call went over 1 hour, and we had so many other pending questions that we decided to just roll into this week with Judge Landers, and he was very kind to accept. So let me quickly explain to you, I'm not an attorney, I'm not a CPA, I'm just an expert in the world of investing. And as many of you know, I'm a hedge fund manager, have been so since 2009. We do very well with the hedge fund, MIXIF, Metawar International Group Secured Income Fund. We're actually growing like crazy. We have some wonderful properties. And we also have the education company, CMREI.com, which is a great pleasure to always meet you guys in person. And now we do a lot online and with webinars. So I'm glad to hear so many people joining us and listening to these calls that we do. We have a joint venture program to find special properties and assign them to the fund. And the call tonight's about asset protection. And as you know, I have written a book about commercial real estate. It was published last year, first quarter, Blue Ocean Opportunity. It became a bestseller. And then at the end of the year, I wrote a book with Steve Forbes called Successonomics. That book actually, they have actually selected a number of wealth advisors in the United States to write the book with him. And I'm in chapter 2, right after Steve Forbes. They loved the 12 steps. I created something called 12 Steps to Financial Freedom, where anyone, it doesn't matter where they're from, maybe it could be a young kid just going to college, trying to find his way through life or her way through life, maybe an immigrant, maybe somebody an engineer in a different career, and all of a sudden they decide they want to be financially wealthy. I wrote about the 12 steps they have to take. Well, one of the most important steps that got us a lot of feedback was the asset protection, a very unusual way that I have used and has been blessed by very experienced attorneys and experienced judges that said that they like it, that it's powerful, it's unique, and this is what we're going to talk about today. The end goal, so you know, in the financial world is to have peace of mind with good assets that give you the earning power over the years. So ideal scenario in life when it comes to the financial world now, not relationship or spiritual stuff, I'm just talking pure money, is get assets producing reliable and growing income, pay minimum taxes on that income, and protect those assets so you can pass them on to the next generation. So the gist of the call today is to understand I own literally streets on properties. I've done that nationwide with REOs, bank-owned properties, in California with the hedge fund, very high-end properties. In Puerto Rico, where I have a lot of commercial properties in a historic place where it's just very valuable. You see that street here is Cristo Street. And when I started looking into asset protection, I am sad to say that it was just very misleading. Some attorneys would say, separate each building in a separate limited liability company. And it's like so overwhelming. And then, set up all these land trusts that flew through to these anonymous corporations. It was so overwhelming. I remember several times, and being somebody in the education business, I have to find ways that I set up something that I can explain to people that works for me. I like to walk the talk and talk the walk. And I realized if I set up the way they're asking me, first of all, it's going to cost me close to $50,000. It's going to cost me about $9,000 to $10,000 a year to maintain it. And God forbid something happens to me, my wife would be completely confused, not knowing what to do. Moreover, even if I'm clear on what to do with all these entities, every time I got to do something like get a credit line or sell a property or change something, I got to fill out minutes and documents and transfer sheets and stamps and seals. I said, this is too confusing, just not going to work for me. So I want to introduce you to asset protection, the simple, the powerful, and the easy way to set it up, use it, modify it, and unwind it. I have a website, KMAGB. These are the initials for Kiss My Assets Goodbye. And let me tell you, it's kind of a joke. It started as a joke with attorneys when they said, hey, if this guy doesn't set up like this, he's going to kiss his assets goodbye. And we said, you know what? This is what we should call the website. And out of respect, so people don't misunderstand us, we just use the initial KMAGB. So it's a powerful structure, so let's get right into it. You realize if you get into an accident of some sort, there are attorneys that are experts in finding out everything about you. There are people that set up websites to help these attorneys to find you. Look at this one. How to sue your landlord in small claims court. How to sue a doctor. Who can I sue? There are even sites that actually show you exactly how to find out what assets are held under anyone's name, even if there was a change of name in the title on any property or business. So the sources of risk are endless. Divorce, employee actions if you have any employees, guest accidents at home if you have a little party, joint ownership with anyone, any involvement in any business or even a fun activity, general partnerships. If you're serving as a corporate officer or director somewhere and you can actually run the risk of getting sued personally. Let me tell you, owning an asset could be dangerous if you have what? If you have equity. You see, a suit today for an act that happened 10 years ago is very plausible. The best part that you need to know is the insurance may not cover you or may not cover you completely. And I have talked to attorneys that are experts, defenders of insurance companies, and they told me how they are actually clever at finding contributory negligence. So if you're sued for, let's say, $500,000, the insurance just pays $100,000 and you're out. For the $400,000, you got to come up with ways to pay. So how do you protect yourself? You know, you've heard people saying set up all these complicated structures. Living trusts are good, but they're not really all in by themselves asset protection. So family limited partnerships could help, but they're too complicated, cost a lot of money, especially that they don't set them up to give you peace of mind. It just kind of gets convoluted. So when you hear in events, you go to seminars and you talk to attorneys, you want to hear what's out there. You hear a lot of this, separate your assets into different LLCs. There is even a big thing up in Delaware about series LLC. Well, the problem with that is, yes, you have separated your assets, so nobody could go after all the assets at once, but each asset still has equity. And if you're holding assets like many of the students I have in the database, you know, they have assets $250,000, $500,000 in equity, if not millions of dollars. So what's the use of having it in a separate LLC when it can go into a court and you have issues and whatever equity you have, that could be taken away? How about the use of land trust? Land trust in a court of law does not mean that you're going to stay anonymous, because a judge can say, I want to know who's the beneficiary. And guess what? You have to disclose that under oath. Anonymous Nevada corporations do not work. You can look online, you can Google, and you will see cases where judges said, I need to know who are the shareholders, or we're going to take this over. Transferring assets to irrevocable trust, you lose control. Using charitable remainder trust may not be the best setup, because you may have some tax advantages, but you really are losing control over a lot of things for what you have in there. Offshore entities don't work best. As a matter of fact, I avoid them. I don't like to go offshore. I don't like to create issues with the IRS to protect my assets, and I don't want to rely on another country to protect me. I want to stay under the U.S. flag. I don't want to hide from anybody. I want to use the system the right way and use something legal, and I cannot just rely on the insurance completely 100%. So what's the answer? What do? Here is the answer. Get rid of any equity showing in any of your assets. Do not show equity. How do you do that legally and ethically? I'll tell you the simple 6 steps. Number 1, figure out how much equity you have. So write down my home, my investment properties, 1, 2, 3, 4, whatever, however many you have, your business, any business assets you have, receivables, inventory, patents, whatever you have that has value. And then what we will do for you is we'll set up one limited liability company in Wyoming. Wyoming is where they created the LLCs in the early 70s. We have a great team of attorneys that will write for you a special operating agreement that's a business operating agreement that shows reasons for the actual Wyoming company to exist. And now, usually when you set up a company, you're supposed to capitalize it. Some people put, let's say, $100,000, some people put $1,000, and some don't have the money to put it, so they put a promissory note. I promise to put so much money into my LLC. That is an approved structure and setup. So you're going to capitalize it for more than all your equity combined. So if your equity is $1 million, we're going to capitalize it slightly higher than that, say $1.2 million, about 20% higher. Now, since you have no cash, you will owe the LLC the capitalization amount, and we're going to write promissory notes. And the LLC will record liens against these assets. If you have homes, if you have real estate, it will be a trust deed in those non-judicial states. It will be a mortgage note in the judicial states for real estate. And if you have businesses, we'll file what's called UCC-1 for your business. This will show on record that you actually have a lien to the bank for first lien position, and you have a lien to a Wyoming LLC for a second position. It wipes out your equity. If anybody tries to sue you, they're going to see that you owe more than you owe. Your properties will be worth $1 million, but you're actually owing $1.2 million. The liens are recorded to the LLC, so it strips the equity with legal justification and what we call economic substance, meaning this stands in court. You see, anybody want to sue you, the entire system works based on who has money, let's go after him or her. And when there is nothing to pursue in terms of money, even a charging order, if the court gives the plaintiff that's coming after you a charging order, it will have no power because there is nothing to go after. And the best part is he who has a charging order against you and can collect, he will have a tax liability for the amount that he has the court awarded him or her, because that is called phantom income. It's extremely powerful, and I want to talk to Judge Lenders that I have right now with me. Judge Lenders, are you on the call? Judge Lenders?
Can you hear me?
Yes, I can hear you now. Thank you so much for being with us again on the call. And so what's your view, what's your point on equity stripping here and the way we do it? What's your feedback?
Well, I think you've already indicated the general way that equity stripping works. It is a phenomenal process to protect assets if it's done correctly. You've also pointed out some of the ways that it should be done correctly, but it's really something that is almost indefensible to any attack or someone trying to acquire assets, because there are no assets, in fact. So when someone looks at the counter recorders or they're looking for something that might have equity in it, there's simply nothing there because it's all been stripped out. The only caveat is, and I think you hit upon this just for a moment, it has to be legitimate. It certainly does have to be capitalized, and there has to be some legitimate purpose for which it's being done. If there's a note, the note certainly should have a maturity date. It should have some agreement of some sort of how this loan is going to be paid off over a period of time, or something that's going to give some substance, because what you wouldn't want to do if you strip an asset is just have it appear to be a fraudulent transaction. So as long as that's done, it's pretty ironclad.
Yes, wonderful. Judge Lenders, do you mind introducing yourself? We have a bunch of new people. Maybe tell them a little bit on your background and how many years you've been in the legal system.
Oh, no problem at all. Actually, I'm an attorney still practicing in the state of California. I've been practicing law for a little bit over 35 years. My background has been pretty much business development, advising real estate transactions, etc. I'm also a licensed broker and have been for several years, more than 25 years, so I'm very familiar with the area. I have a master's in taxation law, so all of it sort of goes hand in hand with what you're talking about. I did sit on the bench in San Diego in Superior Court as a pro tem judge for approximately 10 years. I'm no longer on the bench now, but during that period of time, I often found out and ran into the exact type of situations that you're talking about. And the good thing about it is judges oftentimes are faced with these things, and many people feel that, well, just because one judge might know it, will all of the judges know it? Absolutely they'll know it. I'll tell you the reason why. This is the law. This is the law that's across the land, whether it's federal or state. Some states might have typically a little bit of difference here and there, but ultimately the substance is still the same. And what judges do when they get ready to have a hearing on these kinds of things, they have what is called law clerks. The law clerks go and they research to the nth degree all of the past presidents, all of the current law, all of the things that the judge will have to have before him or her before they make a final decision. And I can tell you that equity stripping and the asset protection has been a hot topic for a very long period of time. So judges are very much up on this, and if you've got your proverbial ducks in a row, it's very, very solid.
Wonderful. I'm so glad you said that the judges are familiar with this, because after last week's webinar, I had a few people call the office, and I think they were afraid that other judges would not be familiar with it. They said maybe Judge Lander knows because he's more well-versed on real estate. But I'm glad you're saying that this is a known structure. It's not used that often, maybe because it doesn't bring the attorneys that much money, but it actually does work, and it's extremely powerful. Am I right?
Absolutely. In fact, that's the thing that has been upholding equity stripping, is because it has gone through several judges. It's been taken up to appellate courts. And again, I must emphasize, if it's done properly, and I know it would be with your organization because I'm familiar with it, and they go through with the attorneys that have the experience, it's absolutely airtight, and almost without a doubt, if it's done right, it's going to be upheld. Equity stripping is not new. It's a very powerful strategy for asset protection. And once again, judges, they don't have to know everything, because when it ultimately comes down to making a decision, they have other people who put these things together for them. They sit back and they go back into their chambers. They look at the law. They talk to the law clerks. The law clerks, by the way, the law clerks who are doing this work, Sharif, they are attorneys. So they're not some college student who's in law school, et cetera. These are attorneys, but their actual job description is law clerk to the judge. So they go in and they do all of this background information, and then they submit to the judge the opinions and one side or the other, so that the judge can reach a fair and conclusion to whatever is before him or her.
Okay, fantastic. Let me, if I can take a moment, because we talked before about this, let me highlight the 5 key bullet points, what would not make this structure hold up in court, okay? What would not make it hold up in court is, number 1, if you set up the structure after a lawsuit has been initiated against you. Am I right, Judge Landers?
That's correct. That could be deemed a fraudulent transfer.
Wonderful. So you've got to do it. The sooner you guys do it, the better off you are. Number 2, if you have an incomplete or inaccurate operating agreement for that Wyoming LLC that does not reflect the clear business purpose and a separate reason for the capitalization, among other crucial things that would have to be spelled out based on the legal requirements, right? Now, number 3, if you have a poorly drafted promissory note without economic reasons for the capitalization, debt, and structured payment. Number 4, if the lien you have filed is incorrectly worded and or is not in full compliance with your specific state lending laws. Number 5, if you do not make the minimum 1 payment per year to your LLC as instructed in the promissory note, that the way we make it for you. And guys, to avoid all these, use our legal team. I spent a good 7 months last year with all kind of different cases. We got researches, and then Judge Lander stepped in November with us, and we actually spent even time in Puerto Rico discussing some things, so we took it to another level. This is awesome. Good. So Ashley is already texting me right and left, say, I got so many questions, we need to ask Judge Landers. Okay, go ahead, Ashley. Go ahead.
Okay, first question is, I own several residential rental properties in different cities using different LLCs in Michigan. While other municipal issues fines in the LLC name, one of the municipalities bypassed all the LLCs protected and used $3,000 in fines to myself personally and with my driver's license number instead of the LLC. They looked up my name in the public records of the LLC and made me personally liable. My lawyer was weak and did not challenge that. Did that municipality break the law?
Wow, I don't know about Michigan law. Judge Landers, do you know?
No, I'm not sure I understand it was quite long, and someone said something about a driver's license. How did that come about?
Okay.
I'm going to put this. I'm going to table this. Okay.
Okay. What happened is in Michigan, I guess when they have probably code enforcement or some issues like this, or maybe utility liens, they issue them in the name of the whoever is holding the title. I guess they looked him up, got from he had it in an LLC in Michigan. They looked him up and found his driver's license and sent him the fine in his name. Well, let me just assure you, Wyoming LLC does not have the name of the certificates of ownership. They don't ask for the names of the owners or managers, so it is practically anonymous. They will have to send it to the actual, the registered agent. So any way you put it, if you got a lien of some sort, like utility or code enforcement, you'll have to handle it, or it will be a problem for the property. So the Wyoming protects you because of privacy, but you still have to fix whatever issue you have.
Okay, I understand. Yeah, that is correct. I guess maybe I misunderstood something there because I didn't understand the indication of the driver's license. But ultimately, if it's covered under the LLC and the person's name comes up from a code enforcement standpoint, it doesn't matter whether it's LLC or the person. That code enforcement is going to have some effect. You've got to take care of that.
Yeah, because against the property.
Exactly.
Okay, Ashley, another question?
Next question is from Tony. What is the advantage to have an LLC in Wyoming instead of Nevada?
Okay, Nevada, LLC, Nevada, in the C corporation in Nevada, it has a charging order protection, but it costs more to set up, it costs more to maintain, and more attorneys are familiar with the Nevada system than the LLCs that actually give you immediately anonymity in Wyoming, and not many people are familiar with it. Am I correct, Judge Landers?
Yes.
So it costs him less, easier to work with, and a lot better to work with an LLC in Wyoming. If he wants something in Nevada, it will be a C Corp for the charging order protection, but that will cost him a lot more. Nevada now charges even a business license. I mean, we can set him up in Nevada, but it's going to cost him $650 a year to maintain every year instead of $450, and it's going to cost, instead of $200 like Wyoming to set up, it's going to cost $550 to set up.
I don't know of any better structure for LLCs in any of the states than Wyoming. I've done them myself for clients, and I've been very satisfied with it. I've also done Nevada and, of course, California, and they don't come anywhere near the simplicity nor the structure or protection as it does with the Wyoming LLC.
Thank you.
Very good. Next question is coming from Reddy. We have a Nevada Corp, a California LLC, and a Florida LLC. What is the process of transferring these entities into the Wyoming structure you are speaking about?
Okay, wait a minute now. I keep getting questions about transferring. We're not transferring anything to the Wyoming LLC. The Wyoming LLC is simply set up there in Wyoming for us to owe money to it. So if your property is owned under a California LLC, something like this, that's perfectly fine. We're just going to record a lien for capitalizing the Wyoming LLC, and it's going to be recorded against that property in California. Whether it's owned by you in your personal name, it's owned by Nevada LLC, it's owned by California LLC, or a C Corp, doesn't matter. So we're not transferring assets into the Wyoming LLC. So I want to be sure everybody understands the simplest setup. There's no transfer of any assets.
And Sharif, to that question, I just want to let you know there was a second part. The second part was, do you contact the registering agent to cancel these entities before you can set this up, or does your legal team take care of this for us?
Yeah, I mean, we can talk privately to that person and find out exactly why he's got all these entities, but actually, to answer his or her concern, whatever entity you're holding the property in is fine. All we do is we record a lien to owe capitalization money to the Wyoming LLC. So all we do is we literally record the paper. We don't need to transfer ownership. Actually, I don't like transferring ownership because it can trigger the due on sale clause if there is a loan, number one. Number two, it can trigger a tax assessment office from the county recorder's office. I mean, it's a rigmarole of problems that they don't want to go into. But yeah, so I would not transfer. I would just record the lien to the Wyoming LLC.
Got it. All right. Next question is from Evelyn. Is there a cash exchange between the new LLC and the note placed on our own property? If not, is it legal to place such a note in the eye of the IRS?
The note, we're missing the question. Repeat the question, I'm sorry?
She said, is there cash exchange between the new LLC and the promissory note placed on our property? If not, is it legal to place such a note in the eye of the IRS?
Yeah, well, there's no cash exchange. There is actually, I would like to put money into the LLC, but I don't have money, so I'm going to put a note. I owe you $1 million. Well, the LLC is going to say, okay, well, show me proof that you're going to pay me that, so we're going to record it against my property. So yes, the IRS is perfectly fine with it, and Judge Lenders, you can correct me, you know the tax code very well. It's perfectly fine, and we are actually making a payment, so we're getting a deduction into the LLC that receives the payment, which is income, but it's actually a tax-neutral structure because a deduction on one end, income on the other, but I own both.
That's absolutely correct, and you hit all of the crucial points that would fly muster with the IRS. First of all, all you're doing is creating a note, and you're going to pay on the note. The note has a maturity date. The note has interest. The note has an amount of money you're going to pay either monthly or annually, and that's going to pass the muster because all you've done is you've created an encumbrance on the land or the property that is being held someplace else, but the Wyoming LLC is simply the lending organization or the lending entity, and it's holding the paper as collateral.
Exactly. Very good.
Very good.
So no tax liability whatsoever on that.
That's correct. No, it's a loan.
All right. Next question. How is the new LLC protected from creditors?
The new LLC is protected because the Wyoming Act 1729503 has protection against charging orders. So the Wyoming LLC protects us because it's structured like this, and it has the right provisions, and we have all that in the operating agreement that is actually 70-some pages long with all the provisions allowed by law that have been upheld in federal court. Judge Lenders, any additional comments on that?
No, you've hit that right on the head, and I don't have any further comments on that.
All right.
Okay, next question. If you already have an LLC in Nevada, can you charge equity, debt, or note to your LLC in Nevada as you would with the Wyoming LLC?
I mean, you could, but it's not going to be as airtight and as proven to have worked like it has for the Wyoming LLC and the structure it has, because Wyoming has the additional kind of extra step of anonymity that they have to get a subpoena and a court order to go after who the owners are. It just gives you a little bit more layers of protections and delays for anybody trying to come after you. And again, as we said, it's a little bit less expensive to set up, less expensive to maintain, and lawyers are less familiar with Wyoming than they are with Nevada.
And in addition to that, Sharif, the more barriers that are placed, legitimately placed in front of an attorney who's seeking any way that he or she can find assets or find anything that they can attach to create funds for a contingency fund or whatever else they might be looking for. The Nevada, in my opinion, is not going to have as many barriers, and it's not going to have as much secrecy, which is totally legal, as the Wyoming LLC. So the more barriers that are there, the less likely you're going to have someone sniffing around and trying to find out what's going on. So that gives, in my mind, that gives the lean toward the Wyoming LLC, bar none.
Thank you.
All right, next question. How do you protect cash?
Well, simply, when you set up the Wyoming LLC bank account, that's where you can put your cash because it's protected under the Wyoming Act for the charging orders, etc. So cash, bonds, you can also put a trading account the key thing is you do not want to have the Wyoming LLC engaged in any active business that can create liability. But putting cash in there, putting bonds, valuable shares of a company, putting a trading account, these will not create any liability. Am I right, Judge Landers?
Yes, but you're absolutely correct. In addition to that, by putting cash in there, you could go even one step further. Once the Wyoming LLC is set up, let's say the cash is put there, you can convert that cash, by the way, into a non-exempt asset also. And I'm sure Sharif would be providing the information in terms of how to do that, because you can turn that cash into an insurance contract or some annuity for something along those lines, and that also gets it into the exempt category. But that may be a subject beyond for tonight, but I just wanted to throw that out since the cash issue came up.
Very good.
All right, we have a couple questions coming in from Maria. The first one is, we asked legal counsel about this structure. They say it isn't clear what the economic purpose is for the loan between the business and the LLC, and who is proposed to be the owner of the new LLC.
The proposed owner of the LLC is actually the husband and wife, whoever owns the property and the assets. They are the actual owners. So number one. Number two, the economic substance is it's not like it's a fake loan. It's not like it's a friendly loan. It is actually capitalizing an entity. And when you capitalize an entity, you can put cash or you can put a note that, yes, I will pay based on this installment payment structure. That gives it what's called economic reason. So this is, that attorney that did not understand it, maybe he thought it's a loan. Instead, it's a lien because of a promissory note. Judge Landers, any additional points?
Yeah, you're right. It is a lien. It's not a loan. And I think, although I don't know specifics with respect to the attorney, that attorney may be referring to the fact that, for instance, I'll give you a very quick example. Bankruptcy courts apply what they call a 5 factors test to determine if equity stripping and that kind of thing is legitimate. You have to factor in the controls. And the controls that you've outlined thus far, Sharif, those are the kinds of things that the courts would be looking for. But I'll give you very quickly some indicia that the courts look at. One is whether the ultimate financial failure was caused by undercapitalization, whether the note included payment provisions and a fixed maturity date, all of which you've talked about, whether a note or other debt document was actually executed, because sometimes if it's not executed, it's not going to stand up in court. But of course, you've already outlined that's what you do. Whether advances were used to acquire capital assets and how debts were treated in the business records. All of these are what they call the totality of facts and circumstances that the courts look at. But based upon what you're saying, all of these are covered in that I think it's some 70-page agreement that you exactly operating agreement that you've got. So that is what I think the lawyer might be talking about. So as long as you've got those things covered, it's absolutely appropriate.
Thank you. You know, Maria, after you set up and you get the operating agreement, show it to that attorney, and he'll probably be an affiliate of our offices. I'm making a joke.
And I'll provide
okay, Ashley, go ahead.
Okay, again for Maria. Judge Landers said that we should set this up the sooner the better. What if our corporation already owes back rent to our landlord, but the dispute is over the amount of back rent due? Will this structure protect us if sued? Everything is set up through the corporation, no personal guarantee. This question, this is actually from Victor.
Well, if there's already a dispute, and I have no idea how much money is involved, etc., if there's already a dispute and then you do something, that is an anticipatory possibility that could possibly create a problem. But I would not necessarily not go ahead and execute the LLC if you've got other legitimate reasons for doing it, and that's not the main motivating factor, particularly if this amount of money or dispute between you and the landlord is not that significant. Now, if you're talking about hundreds of thousands of dollars and then you go do this, and you have nothing else, no other legitimate reason for doing it other than that, then that possibly could set up a situation where it could be concluded as a fraudulent conveyance or some sort of a scheme, and then the protection could be pierced. So I don't know enough facts other than what I've just shared with you to answer that. Hopefully that clarifies it a little bit. But if you're not talking about a substantial amount of money, I wouldn't be concerned about it.
Very good point. So they should settle on that dispute first. That would be ideal. Very good.
Exactly.
Okay, another question. How do we know our assets won't be stolen by some third party under a potential loophole in this structure?
Because they are in full control. They are actually, the paperwork is sent back to them, and the paperwork has no power until they actually print it from the email, sign it, notarize it, and then physically either take it to the county to record or mail it to the county with the notary. I mean, there is no way for anybody in the middle to actually fake their signature and get a notary and get a signature of a husband and wife on a property or something. This is practically impossible.
Yeah, I don't see any way a third party outside of the LLC and the owners who already have the property in some other entity. I don't see how that would pose a significant threat, unless I'm missing something.
There's absolutely no way. All you're giving us is addresses and how much you want the promissory notes to be drafted for. So we send you the promissory notes based on the state where the properties are. We send you the liens based on the states where the properties are, the operating agreement based on, the amount that you told us, and all the stuff that we do. We send it all to you by email and with specific instructions, and then you print it and you go and sign with the notary and then send it over. Without that signature with the notary and sending it, which we let you do, we don't even do on your behalf. We keep you in full control of it. There is just no way. There's not even a 1 in a million chance.
And just let me add this, because I do understand that it's human nature to feel that when you have such a powerful process that can protect you and you're not familiar with this, there's a tendency to feel that, well, there must be something wrong with it. There's absolutely nothing wrong with it. It's very, very powerful. Extremely wealthy individuals have been using this for I can't tell you how long, and it's time for people who are everyday Roys and Jones and Janes to get the handle of this, because if you don't, you're going to be sitting ducks. And this is not a scare tactic, but I see this time and time again that comes across my desk. And all they had to do was just do what Sharif is trying to suggest to you. And even if you didn't do it with Sharif, and I know that's the way he feels also, even if you didn't do it with him, we suggest that you do it. But by all means, if you're going to do it, I think the best avenue would be to stick with Sharif, because I've looked at his program and it's excellent.
Thanks. Thank you.
Okay, next question.
Mm-hmm.
What if merchandise is put in there for a working retail store? Is it protected?
Well, this goes under the UCC1 filing for the business. So the business, we're going to put, let's say you can create an inventory for the merchandise of, let's say, 100,000 in merchandise inventory, 50,000 in desks and equipment and computers and machinery. You got a lease in the mall worth so much, and you have a building worth so much, and a couple trucks, and the whole thing is worth $700,000. Then we may be able to actually file a UCC1 filing against the business for, let's say, $900,000 or $1 million based on, the value of the whole business. So that includes all that good stuff, receivables, etc. So yes, to answer the question, yes, that will be very well protected.
Okay. Next question. Is there a 2-year seasoning period that begins once I transfer my assets? I heard of this before.
The 2-year seasoning works out great for bankruptcy situations where if you set it up and 24 months later, at least 24 months, you've been actually have the structure in place, following everything as per the structure, which we tell you, we send you the instruction, which is very simple, just 2 payments during the 24 months, so 1 payment per year. On the 25th month, if somebody's filing bankruptcy, it may, I'm not saying always, and Judge Lenders, you can correct me, it may be approved by the courts for the bankruptcy court to say, okay, that's okay, we're going to consider the LLC as a creditor, and we're going to just, keep that whole structure. You're not hiding assets. It has been structured for at least 2 years.
And I think the nomenclature to say may is absolutely appropriate, because every deal has to stand on its own 2 feet. We can't generalize and say, yes, this is what it's going to be, because the court will absolutely look at every instance on its own merits.
Yeah, we're talking about bankruptcy court here. And
right.
And so ideally, bankruptcy court, if you look at the bankruptcy court paperwork, which we do have a copy, and actually, it's funny enough, I was reviewing it this morning with a student that was setting up, and he said, well, I may file bankruptcy 4 or 5 years down the road. Would that be affected if things don't turn around? So we pulled the paperwork, we reviewed it, and we saw that they said 24 months. All assets had to have been 24, so that 2 years period. And I'll say, even to go safer, make sure you disclose everything on that form that says disclose your assets when you do bankruptcy. You never try to hide. We disclose everything, and that's the power of this structure. Yes, Ashley.
Okay, next question. How do I file taxes for this structure?
Well, simply like you file taxes, the LLC will be a flow-through entity. It will come back to you. So when you go do your taxes with the CPA, you're going to say, I have this entity, flow-through entity. I made a payment of $5,000 to the entity, and it went to this account, and it came to me. It flows through to me. So it's just very simple. The CPA will handle that for you. It's a tax-neutral structure. It's very inexpensive to file taxes for it, unless you're going to do a lot of trading from that account or have a lot of cash transactions, etc. It should not even cost you that much additional for your tax filing.
Okay. Next question. Does an actual attorney at your company set this structure up for us?
Yes. There are 2 attorneys in that office, and I'm working with that team. And but the resident agent is not an attorney. It's somebody that works with them, and they work with me exclusively for this structure. Actually, they do different structures. Their standard structure is $15,000. And when I met with them and convinced them that this is the structure I want, and I want it to be $5,000, additional liens will be something separate, and we should not be charging $1,500 for each promissory note, etc., etc. I got you guys, and all the listeners here, and all the students we have in our database, the best structure for the least amount of money, and it's something you do once, and you'll have it for a lifetime. You pay for it once, and all you do is just renew it. It doesn't matter if your assets are worth $10 million. Or worth $1 million, it's the same. It's a perfect setup. So yes.
All right. Charlie's asking, does this structure protect our retirement accounts?
Well, I think Judge Lenders answered that last time. Judge, do you want to answer this?
Yeah. Yes. The structure actually doesn't have anything to do with retirement accounts, because retirement accounts are in an entirely different asset protection category. When it comes to asset protection, there's 2 basic categories. There's an exempt category and a non-exempt category. What Sharif is talking about is the non-exempt categories and then how to protect them. If you move over into the exempt categories, that would be your 401ks, the IRAs, the 403bs, etc., and some insurance plans such as variable life insurances, and etc.
So it's protected for them in a separate category.
That is correct. That is correct. They would not be able to go in and get a charging order to say go into a 401k. No, those are exempt categories set up by the federal government through the various IRS codes and the regulations. And I sort of alluded to that earlier when one said, well, what might happen if there's cash? So you could actually take the cash from the LLC and you could turn it into one of those exempt categories, so you would have double protection if you were going to use a Wyoming corporation. Excuse me, an LLC.
LLC, yes. So transfer the cash into that Wyoming LLC bank account, and you still have full control of it.
Exactly.
Very good. Very good. Thank you. Okay, Ashley.
Next question. Do I save money on liability insurance with this asset protection structure?
do you save money with liability insurance? This is not a substitution for insurance. You should always have maximum insurance, all risk insurance, plus umbrella insurance for all your assets, and then protect yourself from whatever will be exempted from the insurance and whoever is going to come after you with punitive damages, etc. So here are the lines of defense. Number one, act prudently. Number two, have insurance, the liability insurance, all risk insurance, etc. Number three, get umbrella insurance. Number four, strip the equity legally with economic substance, with proper paperwork. And number five, enjoy life. That's it. You're in good shape.
Anything to add, Judge?
Yeah, I think that when you start talking in terms of asset protection, you want to look at it from what I call a bird's eye view, because what we're talking about tonight is just one aspect of asset protection that is going to get you covered for probably the weakest link in asset protection, and that is your non-exempt assets that could be encumbered and could be attached. Insurance is certainly a part of asset protection, but you never want to skimp on that simply because you're going to use an asset protection modality such as the LLC. The reason being is the insurance should be looked at as one of the first lines of defense, and you should always make sure that you have sufficient amount of insurance to cover any possible situations that will come up where insurance is appropriate. Without that, you're going to be lagging, and out of the three legs of the stool, so to speak, that's one of the strongest ones. The one that we're talking about tonight is another strongest one, and then the other one would be the exempt category that I just highlighted. So it's kind of like a three-leg stool. You want those to be in equilibrium at all times.
Very good point. Good. Actually, what else? What other question? Thank you, Judge.
All right.
Great stuff.
Can you put a promissory note on other tangible property that has no registration or serial numbers, like antiques, jewelry, paintings, rare gold, coins, etc.?
What I suggest they do is we can change ownership and put the ownership under the actual Wyoming LLC. We had somebody that has very valuable paintings, and they had a certificate, and they just had to fill out who the ownership is going to be, and he was going to put his name and his wife's name, and we said just put it under the Wyoming LLC's name. This way it's protected with the charging orders and the Wyoming Act. Am I correct, Judge Landers?
Yes.
Very good. Yeah, keep it simple. I mean, these people will not have to complicate themselves and their lives.
All right. Next question. Most of the questions seem to already have an existing LLC, and they want to add a Wyoming LLC. But if I'm just starting off, should I just start off with a Wyoming LLC, then do the promissory note, or the other way around?
Well, simple. If you have properties already in your name, we are going to actually set up the Wyoming LLC, do the promissory notes for you, send you everything. Within 72 hours, you'll be set up. If your properties already are in some type of LLC, let's say you're in New York and you have a New York LLC, or you're in Texas, the Texas LLC, we will still set up the Wyoming LLC, send you the documents, and you will go record them. It doesn't make any difference at what point you're starting. I have a lot of properties in my personal name, and it makes it very easy for me to get the best loans, very easy to get insurance, very easy to get credit lines, and I also strip the equity by having the Wyoming LLC and owing money to it for capitalization. So it doesn't matter where you're starting. It's the same structure.
Anything to add, Judge?
No, I think he's done well with that explanation.
All right, Sharif, you're really going to like this next one. Evelyn is asking, since the business equity changes on a yearly basis, how do I determine the value of my business and of the note?
Okay, we can help people determine the value of the business. I'm surprised how many people don't know the value of their business. I mean, I'm glad Judge Lender has a lot of business experience on this, but I mean, really, how much is your business grossing? How much is your business netting, etc.? And you can even ask a business broker, how much is my business worth if I'm going to sell my business? And if your broker tells you, the business broker tells you $150,000, guess what? Let's go ahead and strip the equity for $175 or $200. Did I answer the question? Was there another part to that question?
No, that's it.
Okay.
I think she was just asking because her business changes each year. Is she supposed to change the document each year?
No. Don't have to change the document each year. Just let's get the best year, best value you could have sold it at, and let's find the UCC1 filing based on that value. Remember, you're keeping the certificate of ownerships for the LLC, so if you want to sell the business, you can remove the lien because you're in control of that paperwork and you're the one in charge.
Very good. Michael's asking you to review once more the 5 things that you said that the court needs these people to do with this structure. He's saying after you stated the promissory note had to be properly drafted, you were talking about making sure that the annual payments were made to the LLC. Can you please review?
Okay, the judge, they were talking about the 5 factors test, the control, that it's not undercapitalized, that the payments are being made, that it is executed properly, and that there are capital assets, I think, behind it. Am I correct, Judge?
Right, and it has to have a fixed maturity date, just like any other mortgage. Some mortgages are 30 years, 40 years, etc. So even if you had a loan that says 5 years, you want to have a maturity date in there someplace. Otherwise, it's called an illusory contract. This thing can just go on forever, and we don't know what's going on. So just make sure that there's a maturity date in there somewhere.
Yes, and for the listeners, you guys don't have to worry about all these legalese. I mean, that's why we have an operating agreement that's so airtight, that works so well, and the promissory notes are drafted based on different states. For instance, you could have a property in Wisconsin, a property in Wyoming, a property in Florida, and a property in California. Well, guess what? If I send you the promissory notes and the liens, you're going to see some differences because each one has to be in compliance with the state laws and all this. We have all this. We've done all the research. We already have a structure. We've been doing this since last year. So all this will be handled for you.
And when you say all of this would be handled, including all of the 5 points that I've just talked about, and that's why I wanted to specifically bring that out, because I know that's part of your program. So all of those points, whoever's concerned about these 5 points that I pointed out, that's what you'd be getting as part of the program. Correct, Sharif?
That's exactly, yes, as you recall. I mean, I remember when Judge Landers and I talked about this, he said, let's review the operating agreement, and we sat down and we went line by line, and, you know, I remember you were impressed, and I was really glad. We had a very nice chat, and from there our relationship even prospered more and more, and that's when you came to Puerto Rico. It was a whole different level.
Yeah, I really enjoyed that.
Thank you.
Next question from John. Is it hard to get a loan from a bank with this structure?
Not at all. As a matter of fact, you just explained to the bank, the reason there is no equity here is because I have this Wyoming LLC and I do it for asset protection, and you explain it. I mean, I remember explaining it to Wells Fargo, and they were quite impressed. The money's owed to you.
Judge, would you like to add anything?
Well, I just thought about a little of a joke, because he said, well, they're going to be impressed. And I find that banks like very sophisticated people when they come in. You're probably going to be more sophisticated than the banker, and that's going to be a plus, not a negative.
True.
Very good.
All right, Sharif, this next thing is from Maria, and it's long and detailed, so I just want to read it, and you guys let me repeat it if you need to. But the landlord is asking us to sign a new lease, which we will do in good faith. Our business is solvent, but we may have a tough time making it down the line, since he wants us to pay $125,000 back rent in 2 lump sums over the next 8 months, plus $3,000 more than we are accustomed to paying for rent. Should we sign and have to bail out? Would we still be in jeopardy of fraudulent conveyance at this point? What would a judge consider sufficient passage of time to rule out fraudulent conveyance?
Full disclosure. You've just outlined what the details are with respect to this one unfortunate situation you have with the landlord. But again, if you're using the LLC as an overall business strategy, and you clearly are not trying to get around the responsibility, and it appears to me that what you're trying to do is work it out with the landlord, And all of this is part of the disclosure aspects of it. There's nothing fraudulent about that. Where you get into trouble is if you're trying to hide something and you're doing this, in fact, to try and get out of paying it. Now that it's out front and it's above board, I think that's how you deal with it. And I don't see that there will be a problem so long as there's full disclosure.
Thank you. I mean, I can add to that. I would love to help Maria. If Maria, you're going to set up this structure, I'm more than happy to step in and help you with that landlord negotiation. I've been a landlord with the retail tenants forever, and I've helped a couple other students that actually have been students in Puerto Rico, etc. So would love to take a closer look at your negotiations with the landlord. Maybe we can help you out. I think that it's like Judge. Go ahead, Judge.
No, I was going to ask, what state is this in?
Yeah.
Is it okay if I try to bring her on to the line?
Yeah, bring her on.
Okay, let me see if we can do this. Maria, I'm going to unmute you so you can talk to us. Maria, you're unmuted.
Hello, Maria.
Maria? Don't be
Maybe
shy.
She's afraid of the landlord. I'm just kidding.
Well, one of the things I heard, Ashley, was that she said the landlord is trying to get them to renew the lease. Was that correct?
Yes.
Yeah.
Okay,
yeah.
So obviously there's a debt that she's admittedly owes that is still outstanding, but now he wants them to renew the lease. That's one of the things that needs to be negotiated, because if he or she is wanting them to renew the lease, there's a number of things that come to mind that she might not be aware of. And just for everybody out there, if you have commercial leases, specifically in the state of California, that's why I asked, and probably all across the land, there's some caveats and some language that now has to be in there for purposes of ADA compliance. And 90% of them are not in compliance. So that's a real stickler and a very heavy negotiation point. And you can use that to negotiate possibly even some of the monies that's involved now, but that's another story. I'll be happy to support and help Sharif go down that road. If you decide to deal with Sharif, I would be happy to work with you to do that, because the Americans with Disabilities Act, although it's kind of esoteric, it's extremely, extremely powerful when it comes to dealing with landlords and leases. And I would gather to say that this landlord may not be sophisticated enough to know this area of the law, and if not, we could help you negotiate and maybe just dissipate a lot of that money.
Fantastic.
Great, and just by the way, Maria's in California.
Hallelujah.
That's even better.
That's great.
Very good. So, Maria, here's the deal. When we're done, I want you to call the office, because we're going to set you up. Judge Lender, would you be able to spend like a few minutes with her tomorrow? Is that possible at all? And we see if you could maybe even assist in this case, like
it depends. If you call me between, I'd say 10 and 11 tomorrow, Sharif, just give me on the phone. I'll sort of be looking out for the call. I've got quite a bit tomorrow, but at that time I could probably take a call.
Perfect.
Okay,
and I'll set up a conference call line, because she said that she'd like to have her store manager on the call too.
Okay.
Okay. I think we may be able to get somewhere with Maria and help her out, set you up with asset protection, and help you negotiate with the landlord. And you know what? Sooner or later, Maria, you should be the landlord. You should be leasing from yourself. You know what the whole training is all about. So we're going to get you there. Good. What other questions we have, Ashley?
Let's see. A second part to her question, I just want to answer her tonight. She said, we want to do a search of our personal assets, just like an opposing lawyer would. Can you advise us on a legitimate professional service to use for such a search that we can conduct ourselves?
Okay, I can, I mean, there are websites like the one whocanisue.com, and actually if she Googles finding assets, you will be amazed the websites that will come up. Suing someone, and you see the websites that will come up. Unfortunately, however, a lot of these websites need ongoing memberships, and you'll have to prepay for searches, etc. But yes, you will find these. I don't know, Judge, you want to add any of these?
Well, there's a number of skip trace, and you've already told her. If she just Googles skip trace, it's going to come up a number of them. There's probably some wherever city she's in California. If you Google it, skip traces in San Leandro or San Francisco, you're going to come up with dozens of them, and you can just talk to them and tell them what's going on, and they'll tell you how much it would cost, etc. But be very careful because some are difference between night and day. But when we discuss it tomorrow, that may be something that I could specifically point you to also.
Yes, yes. Right. I mean, there is. Okay, go ahead, Ashley.
I have two more questions. Next question.
By the way, I just want to mention something. Like, if you go to actually skiptraces.com, it's an asset searches, insurance claims, fraud, white-collar crime, all that stuff. They serve attorneys, paralegals, insurance companies.
Right.
Skiptracer.com, skiptracepros.com. I mean, that particular word is extremely powerful in the actual. And then you can do skiptracebusiness.com. There's just plenty of stuff to tell you how to find assets on people.
Exactly.
Okay.
And almost any of them, they're licensed, they're registered with the state. So, but the price is what I'm talking about. So you need to get someone that's going to be fair with you because sometimes they can be rather exorbitant, in my opinion.
Okay. Okay. Very good.
All right.
Okay.
Next question. This structure seems so good, too good to be true. Is equity stripping looked negatively through the court's eyes?
No,
Judge.
Not at all. It's a business, a very legitimate business tactic. It's been recognized. It's been legalized. There's several court cases that support it. Where it's not supported, if the transaction clearly holds itself out to appear to be a scheme or fraudulent transfer, that's when the courts take a dim view of it. Otherwise, it's perfectly legitimate.
Thank you,
very prudent, as a matter of fact.
Thank you.
Oh, next question is from Vance. He said, oh, I guess it's not a question. I know Sharif and Judge Landers and the real estate industry for 40 plus years, and this is the best asset protection program available, period. I have seen many over the years, and this is the best. Thanks, Vance.
Oh, thank you. That's very nice.
Great.
Next question. If the business is valued at $5 million presently, and then the lien is written for $6 million when filed, and I assume a year from now the business is going to increase to $7 million, am I exposed now for $1 million in asset value?
Well, not now, but maybe in the future. And if the business jumps to, let's say, 10 million, I mean, now we're talking, okay, we thought we're going to strip it at 20% more, and we have a negative amortization on the lien, so it keeps increasing until a balloon payoff at the end, etc. If somehow the business doubled or some real estate all of a sudden, I don't know, your area has just boomed and you need modification for the lien amount and the promissory note, we're not going to charge you the entire $695 for that actual lien. We're just going to do an adjustment at 50% off, so $350. We will redo the promissory note for larger amount, the lien for larger amount, and then you will record that. So we will work with you. We want you protected for long term, but these are such rare occasions because when we set it up, we're already ahead of the game for what the future value would be, slightly more than it is today.
All right, Sharif. I believe we just covered our last question.
How about that? We did it in 1 hour and 4 minutes. Judge Landers, you're the best. Thank you for that.
Well, thanks for having me. I enjoyed it.
Thank you, sir. Let me wrap up. Let's see a couple things here. For those of you that want to set up this, let me tell you, first of all, I want you to figure out how many assets you have and how much in total equity you have. We're going to get you Wyoming LLC set up, but I need you to call the office. We're going to give you everything in one package. It's $4,995, including one entity to be stripped, like your home, for instance, and the Wyoming filing fees. Those that are actually doing this today, it's pretty simple. We will guide you through it over the phone. I want you to understand that Wyoming has an Act 1729-503 that protects you from charging orders. The actual Wyoming LLC operating agreement has all the legal and business reasons you need to protect yourself. And the promissory notes have interest-only payments, so you have negative amortization, so you don't have to have a monthly payment. You don't have to have big payments, even though you're making the payment to yourself. It will be a minimum payment, a small payment amount to make it legal, to make it pass the test in the court of law. You do not need to pay ongoing legal fees every time you transact with this because you're in full control. You have all the certificate of ownership. You're in control of the structure. You have the paperwork. You print it. You show it. We're easily accessible to answer any question, but you will see that once you see it, it's easy to work with it. It will offer you full privacy as owners and managers. And anybody trying to sue you, any attorney that wants to go after your money is going to be completely discouraged because there is no equity to go after. So it gives you a huge advantage. It's a lawsuit deterrent. And again, keep your insurance, keep the actual structures that you have, and you don't have to transfer any assets. We're just going to strip the equity. The litigants will end up pursuing a lawsuit against you. If they win with a charging order, the Internal Revenue Code section 77-137 will actually charge them a phantom income tax. So people way before that will try to settle with you or just drop the lawsuit altogether. And the biggest question we've had, by the way, last week was, hey, can I pass on this to my loved ones? I mean, I'm going to read to you the question the way it was asked of us. Since the Wyoming LLC would have all the promissory notes and liens owed to it, practically my entire net worth and all my equity, what would happen when I die? How can I make sure the LLC will not go through probate and will just be passed on to my loved ones without delays or hassles? Well, listen to me carefully, guys. If you have a living trust already, then we'll put the certificates of ownerships of the Wyoming LLC into that existing trust. If you do not have a living trust, then I have created with the legal team this week a simple 8-page trust document that will work for you regarding the Wyoming LLC. Now, living trust could be $10,000, could $5,000, could just put everything. I'm just making it simple for you. It's a simple 8-page trust document where you can put the Wyoming LLC in it. I want you, when you call the office tonight, all I need you to do is when you call the office, give them the name of the trust. So if you're going to call it ABC Trust, whatever name you want to call it. Who is the grantor, which is you and your spouse. The name of the beneficiary, maybe your kids. And the name of a trustee in case the grantor, in case you guys die, okay, then who is someone else you trust that will actually continue this and pass on the wealth, etc. We will have our legal team fill out the 8 pages for you. We'll send it by email with all the Wyoming legal structure, operating agreement, everything. And all you got to do is notarize it and keep it somewhere safe. This trust costs, this actual living trust costs $495, which is the best deal I could get you. Let me tell you, I worked for a billionaire and he stripped equities and he's done it, and I learned how it's done. Edmond Bissari had guided me from the early 80s. This structure has been out and about since the early 70s. So those that want to do this, I want you to call the office tonight, 407-608-5448. Again, 407-608-5448. I have a 2-page, simple, easy document for you to fill out so we can get you started. I will give you a bonus tonight. Those that actually set up tonight, the simple 8-page living trust filled out for you is going to be done by the legal team for you. All I need is the 4 things I just mentioned. Zach, Ashley, and everybody's going to tell you about it. It will be free of charge for those setting up tonight. I will pay for that $500. I want you to call 407-608-5448. If you don't have any loved ones, that's when you think of your CMREI good team. We have good people, Ashley Jones, Zach, Leilani, Kevin. They could be your loved ones. You can pass on the wealth to them if you have no loved ones. I'm just kidding with you. So, ladies and gentlemen, you have the best asset protection structure. You've heard it from someone who's got 35 plus years in legal background, attorney, knows real estate, brokered real estate, invested in real estate, has been a judge for 10 years, continues to be an active attorney, a gentleman whom I had a pleasure to speak with twice now. I want to thank you again. Roy Lenders, You have been great. And everybody on the call, call us, call the office right now, 407-608-5448. Thank you all.
Okay, good night. Have a good evening.
Thank you, Judge. Take care. Bye-bye, Ashley.
Bye.